Well, welcome everyone, and thank you so much for joining me. Who am I? Well, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us across Ontario, BC, and Alberta. And let me welcome you to your employment law Q&A session. This is the time, this is the place where you get to ask questions about your employment law rights, where you get to learn about this very, very important topic. We all have jobs, we all work, and guess what? We all have rights. Our employment laws, I've said this before, in Ontario, in BC, in Alberta, and across Canada, frankly, are some of the best employment laws in the world. Well, if you don't believe me, ask me a question. Ask me about your rights. Ask me what to do. Ask me what the law does for you. And I can help you understand. I can give you that information and arm you with that knowledge. What can you ask about? Well, really anything to do with your job. Maybe you lost your job and you want to know if that was legal or what you're owed. Maybe you're worried about losing your job and you want to know what to do about it. Maybe you're being mistreated in the workplace. Something happens where you're being bullied or harassed. Maybe you're finding out recently that your job is being changed, your hours, your compensation. Maybe you're put on a temporary layoff. Any of those things and much, much more, you can ask me right now what to do, what does it mean, and is it legal? And I'll answer. I'll tell you what you need to know. You can walk away with that answers right here, right now, live, no strings attached. Now, before I start answering questions, let me give you some other contact information. If you want to learn a lot more about employment law, and if you want to connect with me and my team across Ontario, BC, and Alberta, here's what you do. Very, very easy. Just go to employmentlawyer.ca. You see that right there, employmentlawyer.ca, and you can contact me from there. You'll see the phone numbers there, the email address is there. Lots more information you can read about employment law if you're interested. That's your one-stop shop to get help when it comes to employment law, to workplace rights. That's the place you go to. That's your first line of defense, so to speak. But right now, right here, I'm Lior Samfiru live with Samfiru Tumarkin LLP. And why am I live? Because I'm taking employment law questions right now. I was here last week, last Wednesday, lots of questions from lots of people, and I'm expecting the same thing right now. So let's make sure you get those questions answered. All right, so let's get going. But you can ask your question as you hear me talk. There's a box on your screen. You can type in your question, hit enter, and I'll see that question pop up on my screen. I'll read it and I'll answer it. So let's get going. Let's ask and answer some questions. Oh, yeah. All right. The first question on YouTube from Sir. Does working notice have to be in writing? So let's break this down a bit. Let's talk about what is working notice. Working notice is a situation where the company is telling you you're going to be let go in the future. So you're being let go, but not now, not today. We're going to let you go in the future, and we're giving you a certain amount of notice. Maybe it's a week, maybe it's a month, maybe it's 6 months. And that amount of notice is going to count towards your severance. But for that notice to count towards your severance, for that notice to be effective, it does have to be in writing. Okay, you do have to get notice in writing. If the company says, just so you know, we're going to let you go in 6 months, that's not going to be effective notice. It's not going to count towards your severance, which for the employee is a very good thing. But if you receive that in writing, if the company gives you something in writing that says, here's when your last day is going to be, as a very specific end date, then yes, that notice, whether it's a month or 2 months or however long you got, it counts towards your severance. You're still going to be very, very likely owed more severance at the end of your employment, but the amount of notice that you received will count towards that. Hopefully that makes sense. Sir, if you have any follow-up questions, you know what to do. You can ask them right now. See how easy that was? First question asked, first question answered. Again, I'm Lior Samfiru, the employment lawyer. I see more questions coming in. Bring them on. I'm here. I have time. I have the energy. I want to answer all those questions. So let's make sure we get those answers to you right now. Next question from Usman. I was back from parental leave. I was assigned my title, but assigned a demoted position. Afterwards, I received a termination or offer for demoted position, while temporary cover was offered position. So let's be very clear what happens. If you're on a parental leave, company has to take you back to the same job, same pay, same responsibilities that you had before the leave. They can't keep someone else in your role. If they brought in a replacement to cover for you while you're on a leave, they can't keep that person. They have to move that person out and bring you back to your role. So if you were brought back into a different role, number one, that could be a constructive dismissal, but it could also be a human rights violation, an employment standards violation. In other words, it's completely illegal. And if you are then actually let go, that makes it that much worse. So Usman, what your employers did based on what you've just described to me, illegal in several respects. The good news is you're going to have a couple of options. We can either make the company take it all back and bring you back to the same position, or we can get you the compensation that you're owed. One of those two things. So I can help you either way. So here's your next step, Usman. You connect with me off air. You send me an email or you call me and we'll have that discussion privately and we'll get to work. To connect with me, it's very easy to do, Usman. Employmentlawyer.ca. You see that on the screen? Employmentlawyer.ca. I'll wait for your call or email. Let's discuss this privately because, yeah, what Shuv described, illegal. Don't let the company get away with that. Completely illegal. Usman, thank you for that question. Again, you see how easy that is. Usman really was treated improperly, illegally. He now knows what to do. He knows what it all means. Same with you watching. If you have an issue, a question, you're not sure if something is legal or not, why not ask? And I can tell you. Still have time. Don't wait till the end. I say this every week, and every week it happens. I get a bunch of questions just as we're wrapping up, and I don't get to them. Right now, you have all the time in the world, so ask the question. Just like Stevie. Stevie has our next question, and Stevie asks, when can an employer let you go if you are on a medical leave? So, very good question. So your employer can let you go if when you're ready to come back to work, they've tried and there's no job. So if they can't really let you go while you're on leave in most cases. But if you're ready to come back to work, you say, employer, good news, I'm ready to come back to work. The company has to make all efforts to bring you back. If they've tried and there's nothing, it's just not possible to bring back, the job doesn't exist anymore, then and only then can they let you go with your full severance. But if the company doesn't try to bring you back, doesn't even want you back, and doesn't make that effort, that's also a human rights violation. That's illegal. So generally speaking, that assessment as to whether they can bring you back can only happen at the end of your medical leave. Whether you've been gone a month, 6 months, 2 years, it can only happen at the end. So Stevie, if your employer let you go, whether it's at the beginning of the leave, middle of the leave, or the end of the medical leave, you got to call me right away. Okay, I want to assess whether it's legal or not. I want to make sure you get what you're legally owed. So Stevie, if it's you or someone else you're calling about, connect with me, again, through employmentlawyer.ca. Employmentlawyer.ca is the way to do that. I'm getting lots of questions here. Please bring them on. I promise I'll get to all of them. I want to answer each question that comes in today. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you, for you, answering your employment law questions right now. All right, just like next question, which comes to us from Kat. Kat is joining us from YouTube. Welcome. What should an employee do if they feel like they've been given an inaccurate performance review by a new manager that has no experience working with them? So this is an important question because if you do nothing, if you're just silent about it, it's the same as if you've agreed to it. And if you've agreed to it, it can be held against you later on. So Kat, here's what you do. You send a very nice email. It has to be in writing to either the supervisor or to HR, whoever you think the right person, even to both, it's absolutely fine. And you explain in that email why you disagree with that performance review. You explain why you don't think it's accurate or what facts were wrong or what facts were not considered, and you explain it. Now, all you need to do is that. They don't need to respond to it. Whether they respond to it and whether they agree with you or not, it doesn't matter. What matters is that you didn't accept it. You cannot be considered to have agreed with something that's not right. That's what matters. They may write back and say, we disagree with you. That's fine. But by you responding the way I've said to you, you're protecting yourself so that it can't be held against you, so that the company can't use it later on to try to fire you for cause. So you respond to it very professionally. You don't be rude, don't be aggressive, but in detail. Here's why this is not accurate. 1, 2, 3, 4. Do it that way. And if you do it that way, you're protecting yourself. Kat, hopefully that makes sense. Any follow-up questions, ask me. And of course, if they do at some point use it against you to try to let you go, you call me immediately. Great question. Guys, today some of the best questions already so far, so keep them coming. I'm right here with you, for you, so make sure you ask your question. I know you're watching, okay? But if you're watching, it means you probably have something you're wondering about. You're probably dealing with an issue yourself. Well, don't deal with it alone. I'm right here. I got your back. Let's talk about that issue. All right. Next question comes from storage account. That's what the name says. If the employment contract provides a notice period shorter than the statutory minimum, such as 1 week instead of the required 2 weeks after a year of service, and the employer gives 2 weeks notices instead of the contracted 1 week, can you still sue for wrongful dismissal? Absolutely. So any employment agreement that provides less than the statutory minimums is not worth the paper it was written on. It's unenforceable. It's illegal. So it doesn't matter if the company actually pays more or less. They cannot rely on that agreement to limit your entitlements. Beyond that, I'm going to make this point. There are many reasons, probably 15 or 20 reasons, why an employment agreement that tries to limit your severance doesn't actually do that effectively. So there's a very good chance that if you're an employee that at some point signed an employment agreement that tries to limit your severance, that it actually doesn't do that properly, meaning you're still owed much more severance. So employers often try to limit future severance in an employment agreement. Fortunately, probably 75, 80% of the time, maybe even more, they don't do that properly, meaning they don't do it at all, and you're owed your full severance. And that could be the difference between getting 8 weeks severance and getting 24 months severance. Massive, massive difference. So if you sign an employment agreement that you believe limits your entitlements, doesn't matter. If you're let go, you call me. Okay, there may be many ways and many reasons why we can get you out of that agreement and still get you your full severance. So very good question, storage account, and let's definitely talk. If you lost your job, you need my help. Okay, let's deal with that. Connect with me through employmentlawyer.ca. Now, there's more questions. I'm going to answer them immediately. But before I do, I want to point you to another tool, another resource. If you're wondering how much severance is it that you're owed, what does the employer have to pay you? What are the severance? What is the value of your severance? You can find out right now. You don't even need to call me if you don't want to. To find out right now how much severance you're owed, you grab your smartphone, your tablet, whatever you want, and you go to pocketemploymentlawyer.ca. You see that address on the screen right now, pocketemploymentlawyer.ca. What is that? Well, it's a tool that we created that allows you to find out a lot about your rights. And one of the things that it does, it has our severance calculator tool there. Severance calculator. What does that do? Well, the name says it all. It calculates and it tells you what your severance is. So you go to pocketemploymentlawyer.ca, you click on the severance calculator, and you use that tool. You answer a few questions, and then it's going to tell you if you're owed 6 months severance, 24 months severance, something else. It's free. It's completely anonymous. No names, no phone numbers, no company names. It takes a few seconds, only literally a few seconds, and you get your answer. So you can use it if you just lost your job and you're staring at that severance offer that the company gave you, and you want to know, is it enough? Well, no problem. Go to pocketemploymentlawyer.ca. You can also use it if you think they're about to let you go and you want to be prepared. Again, check it out then. Or maybe you're just curious, or your neighbor lost your job and you want to help them figure out how much severance they're owed. Chances are that whatever they were offered or you were offered if you lost your job is a lot less than what you're actually owed. A lot less. There's a 90% chance. So if you lost your job, first place you go to is pocketemploymentlawyer.ca, or if you prefer, just call me. So check it out, guys, and thank you. And I'm going to continue answering questions right now. Let's see. Usman had a follow-up question. Usman said that he was given a different job coming back from parental leave, and he says the temporary cover was off. The temporary person covering was offered the same job as him. They gave me a restructuring reason. So again, they have to give you the same job. Title doesn't matter. If they gave someone your old job, then that's illegal. So ask them, okay, no problem. Give me this guy's job then. If they say no, again, human rights violation, constructive dismissal, employment standards violation. So Usman, you really want to connect with me off air as soon as possible. I wouldn't wait on this. And again, to connect with me and my team across Ontario, BC, and Alberta, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. Oh, okay. Well, the next question comes from the winner of our best handle name of the day, Chillin' and Relaxin'. I love that. Okay, I feel better just seeing that name. So Chillin' and Relaxin' asks, can I formally request the notes that the interviewer took during my job interview? I suspect they omitted key information. The interview was for a city job in Ontario. Unfortunately, not. No. Well, you can ask for whatever you want, but they have no legal obligation to provide that to you, and you will never get it, unfortunately. There's no mechanism to force the interviewer to give you their notes. So, unfortunately, chilling and relaxing, no. You can ask. I mean, worst thing they can say is no. They're not going to give it to you, and there's no way to get it, unfortunately. All right, good questions. Again, those that are just joining us, well, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and what I've been doing for the last 17 minutes is answering your questions live on employment law issues, helping you resolve those workplace problems, informing you about your legal rights. Still have time, though. If you're just joining us now, or if you've been watching for a while, you have a question for me, why not ask it? Okay, I'm right here for you. I set this time aside specifically to come here, to log on to this platform and make sure that I answer your questions. So I'm going to continue doing just that. Next question comes to us from Deborah. Deborah is joining us on YouTube. I was put on a leave of absence because I wouldn't get vaccinated. No severance, but I did not sign anything to say I had been fired or quit. Is there anything I can do? Well, I'm assuming, Deborah, that you're still not back at work. Otherwise, you wouldn't be writing. If you're not back at work, that is a termination. Yes, you are owed severance. If you were put off work because of your vaccine status, you are owed severance. The company doesn't get to just keep you off. They don't get to make that decision. There is no basis not to have you back. So yeah, they owe you your full severance. So Deborah, in that situation, let's be done with this. Why sit at home and continue wait? That's wrong. So connect with me right away through employmentlawyer.ca. My firm, we've helped hundreds of people across the country in that exact situation. We know what to do. We know how to help you. So Deborah, connect with me through employmentlawyer.ca, and let's get to work. Let's get you what you're owed. Thanks for that question, Deborah. I appreciate it. All right, let's continue answering. Let's see, where did I leave it off? I'm looking, next question from Anna. Anna says, if you are required to work an 8-hour shift and ask to work more hours when needed for the company, can you decline? What are the laws in regards to working extra hours? So you don't have to agree to work more hours than your shift, unless, of course, you signed an employment agreement specifically agreeing to do that. But unless your employment agreement specifically says that, yes, you agree to work whatever shifts we want you to work, you can decline. Keep in mind, though, that your employer can let you go because you decline. Why? Because your employer can let you go for any reason. So they can say, you know what, we're not happy with you, so we're going to let you go. They, of course, would have to pay you your full severance, but they could let you go. Again, that may seem unfair, but remember the rule. Your employer can let you go pretty much for any reason as long as they pay you severance. You know, your employer can say, you drive a blue car, and we just want people with green cars, so we're going to let you go. Now, obviously, that's silly. No employer would do that, but they could let you go in that situation as long as severance is paid. So ultimately, Anna, they could let you go with severance. Now, if you signed an employment agreement agreeing to work extra hours and you say no, in that situation, they may even potentially let you go without severance. So you have to decide ultimately what's better for you. So hopefully that answers the question. And if you have follow-up questions, you know what to do. I'm still right here. Connect with me and ask the follow-up question. All right. Lots of questions. Love this. I love this. Next question comes to us from YouTube from Mary. Can my employer fire me after my probation period without reason, without consequences? So remember what I just said, Mary. Your employer can let you go pretty much for any reason as long as severance is paid. So the consequences for your employer is that they have to pay you severance. So even if you work for a short period of time, let's say you work for 4, 5, 6 months, even in that situation, your severance is likely going to be a few months. So you may think, well, I worked for 5 months. They let me go. Maybe they owe me a week pay or something very small. No, even after 5 months, you could be owed 2, 3, 4, 5 months of severance, depending on the job you're doing, your age, and of course the length of employment. So because of that, yes, they can let you go, but they have to pay severance, and that severance is probably a lot more than you realize. So, Mary, if you were let go, doesn't matter if you work a long time, short time, you call me right away so that we can make sure that you get what you're owed. And of course, to call me, to connect with me, to get the phone number and email address, just go to employmentlawyer.ca. All right, storage account. Sorry, the name. As a follow-up question, if your employer demands a new month of employment, contradicting an oral agreement and offering minimal consideration like $100 bonus, what should you do? Well, you have to decide whether or not you're happy with the new agreement, right? I mean, that's up to you. They can't physically take your hand and make you sign it. So you have to decide. If you say no, they may decide to end your employment. They may have to pay you what they have to pay you, but be very careful with what you've agreed to. Employment agreements are not good for an employee. As an employee, you're better off on a handshake deal. You're better off with an oral agreement. A written employment agreement benefits the employer. There could be many terms there that are bad for you, something that limits your future severance, that gives the company the right to put you on a temporary layoff, to change your job, to change your pay, many other things as well. So is it worth $100? Only you can decide that. Or you can connect with me, have me review the agreement and tell you what it says and what it does. So hopefully that makes sense, storage account. Again, to connect with me, every time I say to connect with me, easy to do. You can just go to employmentlawyer.ca. Again, employmentlawyer.ca. You can pick up the phone number there, the email address there. It's all right there for you. All right, continuing to answer questions right here, right now, live on this session. By the way, I'm Lior Samfiru, the employment lawyer, answering questions live. The next question is from S. Easy enough. If a company flies you to a job and you end up quitting, are they obligated to fly you out, or are you on your own? So if the company sends you to a job, yes, they do have to bring you back at that point. If you did the work that there was, if you went there for work and you did the work. Now, if you flew out there but you didn't do any work, you just quit as soon as you got there, then no, it wouldn't be appropriate for them to fly you out there. But if you did the job that they flew you out to do and then said, okay, I'm not coming back to the office anymore, I'm leaving, they do have to fly you back at that point. So hopefully that makes sense. But if essentially you just got a free ride to get somewhere and didn't do any work, the company can say, well, now you're on your own dime, we're not going to fly you back. Hopefully that makes sense. S, any follow-ups? You know what to do. Very, very easy. And I just see S has another question that says, what entitles a person to receive severance? Losing your job. If you lost your job, you're owed severance. It's as simple as that. If you had a job and you lost it, you are owed severance. In some situations, you can even get severance if you weren't let go, but the company did something to you that made you quit, change your job, change your pay, treated you badly, and they forced you essentially to leave. Even in that situation, we call that constructive dismissal. You are owed severance. All right. Let's see. Who is our next question? Next question is from Sadia. Sadia has our next question. Severance pay calculator is giving me way more than I was offered, but I am given what's in the contract. HR won't negotiate. How to negotiate my severance without incurring upfront legal fees? Well, you call us. It's as simple as that. Most of our cases are on a contingency basis. In other words, we only get paid if we're getting more severance. So it's very simple to do. Now, it's a question of whether or not we can get around that contract. You can't do that on your own. You're not going to know the basis, the ways to get around the contract. I was talking about this earlier in the session. There's probably 15 or 20 ways, maybe more, to get around out of a contract that tries to limit your severance. But you're not going to be able to do that on your own any more than you can perform surgery on your own. So, Sadia, you need to contact us as soon as possible. Do not sign what they've offered you. Let's talk about that. That's our job. Literally, it's what we do every day, 7 days a week. Okay, so let's have us do what we do. Let's get you the severance that you're owed. Or if we review the matter and we find out that there's no way to get you more severance, we'll tell you, and at least you'll know, and you won't wonder anymore. So, Sadia, to connect with me, very easy. My team, easy. Employmentlawyer.ca. Write that down. Employmentlawyer.ca. Phone numbers there, email address there. It's all there to connect with me. So S has a follow-up question. How do you calculate or know how much severance you should receive? Well, I give you a good way to do that. Use the severance calculator. Go to pocketemploymentlawyer.ca, use the severance calculator, or you can call me and I'll ask you a few questions and I'll tell you how much you're owed. The main factors that go into assessing severance is your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. All right, let's see. Questions. Storage account. Does a notice clause in an employment contract override the remaining time? Sorry, where is it? In a fixed term employment for determining reasonable notice. Well, it depends what the termination clause says. I would have to see it. It could or it could not. I'd have to see it. Again, you're asking questions that are very, very good, but there's questions that you can't really assess. You need a lawyer to assess that because it's very technical. So if you're in that situation, you connect with us, let us do our job and make sure that you get what you're owed. Again, employmentlawyer.ca. So Anna says, what if you don't sign an employment agreement? Would this help from being asked to work extra hours? Well, your employer can ask. And as I said, if you didn't sign an agreement, you can say no, but you could lose your job because you could lose your job for any reason as long as the company pays you severance. So not signing an agreement means that the company won't be able to avoid paying you severance. That doesn't mean that they won't let you go. So you have to decide what's better. Am I better off working the extra hours, or am I better off losing my job with severance and saying no? Only you can decide that. All right. I'll take one more question for today, guys. Al-Karim asks, I'm not sure if I missed my turn. I just wanted to know that after 23 years at the age of 57, they fired me with cause. They throw me out very fast. How much severance am I entitled to and back pay from October? So unless you did something terrible, you are absolutely owed severance, and that could be as much as 24 months, 2 years of severance. So you have significant entitlements. So Kareem, here's what you do, and you have to do this now, today. Don't wait on this. You go write this down. You go to employmentlawyer.ca. Again, employmentlawyer.ca. When you go there, you'll see my phone number, my email address. I want you to connect with me right away, today, okay? Connect with me. Tell me I told you to do this during the live stream session. Let me get to work. Let me talk to you, find out obviously more about what happened, and make sure you get the compensation that you deserve. Al-Karim, again, employmentlawyer.ca. Looking forward to connecting with you later today. That's the time that I have for today, guys. Thank you so much. A reminder that tomorrow, Thursday, my colleague Alec Lucifero will be back right here at 12 p.m. Eastern to answer more questions about employment law and disability law as well. So if you want to find out more, you can join Alex tomorrow at 12 p.m. Eastern. I'll be back next week as well, but don't wait until then, all right? Connect with me now if you need help. Employmentlawyer.ca. I'm going to turn off this live stream, but I'm getting back to work. So you can still email me. You can still call me. We can still have a conversation and get you the help that you need. Guys, again, I'm Lior Samfiru with Samfiru Tumarkin LLP. Thank you so much for joining me today. Thank you for all the fantastic questions. It's always a privilege to be here and talk to you. I'll see you all again very soon. Thank you.